Happy New Year, everyone, and welcome to the Equal Opportunities first meeting of 2014. Please set off any electronic devices to flight mode or off. I'd like to start with introductions. At the table we have our clerking and research team, official reporters and broadcasting services. Around the room we are supported by the Security Office, and welcome also to observers in the public gallery. My name is Margaret McCulloch and I am the committee's convener, and I now invite members to introduce themselves in turn, starting here on my right.
Thank you. I'm Marco Biaggi. I'm the SNP MSP for Edinburgh Central, Deputy Convener. Good morning and Happy New Year.
Good morning. Christian Arad, MSP for the North East of Scotland.
John Mason, MSP for Glasgow Shettleston.
Good morning. John Finney, Highlands and Islands.
Alec Johnston, Member from North East Scotland.
Thank you. The first agenda item today is a decision on taking business in private. You're asked to agree to take item 3 in private. Are we all agreed?
Agreed.
That's fine, we're all agreed. The second agenda item is Stage 2, consideration of the Marriage and Civil Partnership Scotland Bill. This is our first meeting at Stage 2 of the Bill. I welcome Alex Neil, the Cabinet Secretary for Health and Wellbeing, and his accompanying officials. Officials, of course, are not permitted to participate in the formal proceedings. Linda Fabiani will join us to speak to her amendments, and everyone should have with them a copy of the bill as introduced, the second marshalled list of amendments and the second groupings of amendments. There will be one debate on each group of amendments. Can I remind you that members who have not lodged amendments in the group but who wish to speak should indicate that by catching my or the clerk's attention, and that only committee members are allowed to vote. Voting in any division is by a show of hands. It is important that members keep their hands clearly raised until the clerk has recorded the vote. The committee is required to indicate formally that it has considered and agreed each section of the bill, and so I will put a question on each section at the appropriate point. We start with Amendment 47, which was debated at our last meeting. As members know, the presiding officer has determined that the potential costs associated with this financial amendment are such that they would cause the bill to require a financial resolution. No financial resolution has been lodged. Under Rule 9(12)(6)(a), the question on the amendment may not be put even if the amendment is pressed. I will allow the Cabinet Secretary to make a brief comment if he wishes to do so.
Convener, thank you very much indeed, and a Happy New Year to everybody here as well. It may be helpful if I say a few words on why the Government has not lodged a financial resolution as a consequence of Amendment 47. Alec Johnson noted on day 1 of Stage 2 that it was not like him to ask the Government to spend money. I indicated on day 1 that it was unlikely we would wish to lodge a financial resolution. Clearly, we need to take care in how we spend public money. Amendment 47 would give rise to potential costs, given that, as Alec himself acknowledged, the amendment is drawn extremely widely. In addition, and as we have made clear, the protections in the bill and in the associated amendments to the UK Equality Act for religious bodies and celebrants are robust. Therefore, we have not lodged a financial resolution, and I hope, Convener, that's a reasonable explanation of the Government's position.
Thank you, Cabinet Secretary. I invite Alex Johnson to make any brief comment he wishes and indicate whether he is present or withdrawn Amendment 47.
I note the comments of the Cabinet Secretary with interest, but believe that there are still issues to be discussed on this subject. I therefore would like to reserve my position in order to perhaps bring this matter back at Stage 3, and consequently at this stage I would seek the Committee's leave to withdraw the amendment.
Alex Johnson is seeking to withdraw Amendment 47. Does any member object? No. If no member objects, Amendment 47 is withdrawn. The question is that sections 15 to 20 be agreed to. Are we all agreed?
Yes.
I now call Amendment 27 in the name of the Cabinet Secretary, already debated with Amendment 25.
Formally move, Convener.
The question is that Amendment 27 be agreed to. Are we all agreed?
Agreed.
The question is that Section 21 be agreed to. Are we all agreed?
Yes.
I now call Amendment 48 in the name of John Mason in a group on its own. John Mason to move and speak to the amendment.
Thank you, Convener. And I think, as is clear from the heading of this amendment, it is called Review of Same-Sex Marriage, and basically is calling for a review in due course at the end of 5 years, basically to see how things have gone and if they have gone as expected. Our previous understanding of marriage as a lifelong exclusive commitment between one man and one woman has been in the norm in Scotland for centuries. This legislation, which changes the definition of marriage, has therefore to be considered as radical, whether one supports it or not. For many people, marriage is seen as a key foundational building block of society, and many people are unhappy about the definition being changed and have real concerns about what the implications might be in due course, for example, in relation to civil liberties, and that is what many of our amendments have sought to focus on. So it's for these reasons that I believe there should be a commitment to review the legislation after 5 years. That's not to say it would be, it's not a sunset clause in the sense that it would only last for 5 years. That's not the point. The point is to review what has actually happened, any implications, any tidying up that needs to be done, and really to assess its impact. If the impact is minimal, then a review would still be worthwhile. If, however, the legislation proves to have severe negative effects, as some of us are concerned, for example, on civil liberties for those who believe in traditional marriage, then it would serve as a means of addressing these.
Thank you. Do any other members wish to speak? No. Cabinet Secretary, do you wish to comment?
Yes, please, Convener. Can I say I do not agree with Amendment 48. The Government does support post-legislative scrutiny of legislation. We have, for example, recently responded to an inquiry by the Justice Committee into the effectiveness of the Title Conditions Scotland Act 2003, and a parliamentary debate took place last week to discuss the outcome of that inquiry. However, I do not support Amendment 48 for a variety of reasons. First of all, the amendment could be perceived as a sunset clause. That is not the right thing to do. We cannot allow people to have a same-sex marriage and then remove that right a few years later. Secondly, the amendment just concentrates on some aspects of the bill. We will also wish to consider in due course the positive outcomes this legislation will bring. The bill allows same-sex couples to get married. It improves the rights of transgender people. It allows religious and belief bodies who wish to solemnise same-sex marriage the opportunity to do so while protecting those who do not. So when we consider the impact of this legislation, we will want to look at the impact as a whole. I agree that we will need to monitor any impact on civil liberties. I don't think there will be any adverse impact, but monitoring is sensible. Equally, though, we will need to monitor positive outcomes such as a reduction in discrimination. Finally, I would suggest the amendment is unhelpful. It would lay down specific requirements on what a review should consider. That could cut across what Parliament, the Government or others may want to do when considering the impact of this particular bill. Therefore, I do not support Amendment 48 and invite the committee to reject it.
Thank you, Cabinet Secretary. John Mason to wind up, press or withdraw.
Thank you, Convener. I suppose I'm a little bit disappointed that there's no kind of sign of movement or anything from the Cabinet Secretary. To say that what is not a sunset clause could be perceived as a sunset clause, I just wonder where we would go with any legislation if we didn't look at what the words actually said and we looked at what the perception might be. While I do accept that perception is always important, as I said in my opening remarks, it was not a sunset clause. It clearly is not a sunset clause. Nobody is suggesting that if this legislation is passed, that it should not continue. But there should be a review. I take on board the Cabinet Secretary's points that a review should perhaps be wider than this, and therefore he could have, or anyone else could have, brought an amendment to say that, and perhaps we can look at that at stage 3. But, I mean, I think the reality is this Parliament has not been good at reviewing legislation, and that's partly just been a lack of time and other commitments that committees have. And I think there is widespread agreement in this Parliament that we should be doing more to go back and review work, and especially legislation that we have done in the past, to see what impact it's had, and that may well be for good or to pick up any problems. So I would want to press my amendment.
The question is that Amendment 48 be agreed to. Are we all agreed? No. Yes. Amendment 40 is not agreed to, so we'll now move to a vote. Can I ask all those in favour of the amendment raise their hands, please? Can I ask all those not in favour raise their hands? The result is 2 votes in favour and 4 votes not in favour, and there were no abstentions. The amendment is therefore disagreed to. The question is now that section 22 to 27 be agreed to. Are we all agreed?
Agreed.
I now call Amendment 50 in the name of the Cabinet Secretary, grouped with Amendments 74, 75 and 76. Cabinet Secretary, to move Amendments 50 and speak to all amendments in the group, please.
I so move, Convener. Amendments 50, 74, 75 and 76 relate to persons who are long-term transition to an acquired gender. Persons who are acquiring a new gender can apply to the Gender Recognition Panel for a Gender Recognition Certificate. Section 3 of the Gender Recognition Act 2004 makes provision on the evidence which should normally be submitted, including evidence relating to the diagnosis of gender dysphoria. Section 27 of the 2004 Act made provision on alternative evidence requirements for persons who had been long-term transitioned. Section 27 has now sunsetted and no longer applies. These amendments are designed to reintroduce alternative evidence requirements for some long-term transitioned people. Amendment 74 makes amendments to the Gender Recognition Act 2004 to make provision on the detailed procedure. Under the procedure, applicants can submit just one report rather than the usual 2. As this bill is about marriage and civil partnership, the applicant must be or have been in a marriage or civil partnership registered in Scotland. And as the provision is about persons who are long-term transitioned, the applicant must have been living in the acquired gender 6 years before the commencement of Section 27 of the Bill, which is the section introducing the schedule on gender recognition. The applicant must have or have had gender dysphoria or have undergone surgery to modify sexual characteristics, or must have undergone other treatment laid down by an order made by Scottish ministers. This order-making power reflects that some applicants may not have had surgery. Surgery may not have been available, or there might have been medical reasons why surgery was not advised. As treatments may vary, the order-making power will enable ministers to seek views on exactly what forms of treatment might be acceptable as evidence under the new procedures. Amendment 76 ensures that any such order will be subject to affirmative procedure. The amendments also contain an order-making power for ministers on any further information or evidence which applicants should provide under the new procedure. Amendment 75 ensures that this order-making power is subject to negative procedure. Amendment 75 also makes a technical change to the bill, reflecting that all orders under Section 5D of the 2004 Act on streamlined procedures for civil partners to obtain full gender recognition certificates will now be subject to affirmative procedures. Finally, Amendment 50 is a consequential amendment. It reflects that there will in future be 2 parts to Schedule 2 of the bill, as Amendment 74 introduces a new Part 2 to the schedule. I therefore move Amendment 50.
Thank you, Cabinet Secretary. Do any other members wish to speak? No. can I ask the Cabinet Secretary then if he would like to wind up?
I think I've probably said enough, hopefully, Convener.
Thank you. Right, where am I now? Questions, yeah. The question is that Amendment 50 be agreed to. Are we all agreed?
Yes.
Yes. Yep. I now call Amendment 51 in the name of the Cabinet Secretary, grouped with Amendments 52, 54, 55, 56 and 67. Cabinet Secretary to move Amendment 51 and speak to all amendments in the group, please.
Thank you, Convener. Amendments 51, 52, 54, 55, 56 and 67 relate to the change of gender of married persons or civil partners. They are, for the most part, technical amendments which tidy up our provisions so that they dovetail appropriately with the provisions in the Marriage Same-Sex Couples Act 2013. The 2013 Act introduced same-sex marriage in England and Wales. It also made other changes, some of which are extended to Scotland. This committee considered and Parliament agreed a legislative consent motion to allow Westminster to legislate for devolved matters. However, when we introduced our bill, we could not take it for granted that the 2013 Act would be passed. As a result, there is some overlap and inconsistencies currently between the two pieces of legislation. Amendment 51 is a minor technical amendment. As it currently stands, a gender recognition certificate may be issued under Sections 4, 5 and 5A of the 2004 Act. However, should the bill be enacted, it will also be possible for gender recognition certificates to be issued under the new Sections 4C and 5D of the 2004 Act. Amendment 51 therefore reflects that in the future, gender recognition certificates may be issued under more provisions in the 2004 Act than is the case now. Amendments 52, 55, 54, 56 and 67 relate to the statutory declaration of consent provisions contained in paragraph 2 of Schedule 2 to the Bill. Amendment 52 removes the definition of statutory declaration of consent. The 2013 Act inserts a definition of statutory declaration of consent into the 2004 Act, which will also extend to Scotland. It is slightly different, however, to the definition contained in the bill. Amendment 52 therefore removes any confusion that might arise by having two definitions of statutory declaration of consent, which would both be extended to Scotland. Amendment 54 removes the new Section 36DB of the 2004 Act being inserted by paragraph 3 of Schedule 2 to this bill. It requires an applicant to the Gender Recognition Panel to provide a statutory declaration on whether marriage was solemnised. This is unnecessary as the 2013 Act already makes similar provision which extends to Scotland. Amendment 55 is a consequence of Amendment 52. It expands slightly the new Section 36DC1 in the 2004 Act to clarify that the statutory declaration referred to is a statutory declaration of consent by the applicant's spouse, that the spouse consents to the marriage continuing after the issue of a full gender recognition certificate. This is in line with the provisions of the 2013 Act. Amendment 56 clarifies exactly what the applicant has to provide to the Gender Recognition Panel by way of statutory declarations. An applicant will either have to 1. Provide a statutory declaration that the spouse consents to the marriage continuing, or 2. Provide a statutory declaration that no such declaration by the applicant's spouse is included in the application. This amendment brings our provisions in this area more into line with the 2013 Act and keeps consistency in the application process for the Gender Recognition Panel. Amendment 67 is also a consequence of Amendment 52 and is a minor technical amendment. It ensures that the reference to statutory declaration of consent in the new subsection 7 of Section 4C of the 2004 Act refers to the updated definition as amended by Amendment 55. I now move Amendment 51.
Thank you, Cabinet Secretary. Do any other members wish to comment? No. The question is that Amendment 51 be agreed to. Are we all agreed? Yes. Okay. I now call Amendment 52 in the name of the Cabinet Secretary, already debated with Amendment 51. Cabinet Secretary to formally move.
Formally move, Convener.
The question is that Amendment 52 be agreed to. Are we all agreed?
Agreed.
Agreed. I now call Amendment 53 in the name of the Cabinet Secretary in a group on its own. Cabinet Secretary to move and speak to amendment.
Thank you very much indeed, Convener. Schedule 2 to the Bill amends the Gender Recognition Act 2004 to enable marriages solemnised in Scotland to continue where one or both parties change their gender and both parties wish to remain married. The amendments to the 2004 Act define a marriage solemnised in Scotland as a protected Scottish marriage. This definition includes a marriage solemnised overseas through UK consular services where the couple elects Scotland as a relevant part of the United Kingdom. Schedule 6 to the Marriage Same-Sex Couples Act 2013 introduces new provisions in relation to these consular marriages. Amendment 53 amends the interpretation section of the 2004 Act. This ensures that marriages solemnised under the new provisions in Schedule 6 to the 2013 Act are, for the purposes of Schedule 2 to the Bill, included as having been solemnised in Scotland so long as the couple elected Scotland as a relevant part of the United Kingdom. Finally, Schedule 2 to the Bill will continue to cover UK consular marriages where the couple elected Scotland which took place under the current provisions contained in the Foreign Marriage Act 1892. And despite the rumours I wasn't around at the time of that Act being passed, I move Amendment 53.
Thank you, Cabinet Secretary. Do any other members wish to speak? The question is that Amendment 53 be agreed to. Are we all agreed? Agreed. I now call Amendment 54, 55 and 56, all in the name of the Cabinet Secretary and all previously debated. I now invite the Cabinet Secretary to move Amendment 54 to 56 on block.
Move on block, Convener.
I now ask whether any members object to a single question being put on Amendment 54 to 56. No. If no member objects, the question is that Amendments 54 to 56 are all agreed to. Are we all agreed?
Agreed.
Agreed. I now call Amendment 57 in the name of the Cabinet Secretary, grouped with other amendments as shown in the groupings. Cabinet Secretary to move Amendment 57 and speak to all amendments in the group, please.
Thank you, Convener. Amendments 57, 58, 59, 60, 61, 62, 63, 64, 65, 66, 69, 71 and 73 are designed to ensure that the Marriage Same-Sex Couples Act 2013, passed at Westminster in this bill, work effectively together. In particular, Schedule 5 to the 2013 Act extends to Scotland. Schedule 5 amends the Gender Recognition Act 2004 and relates to persons in a marriage solemnised in England and Wales or overseas or in a civil partnership registered in England and Wales. Schedule 5 extends to Scotland as people in such marriages and civil partnerships may now live here. Therefore, Schedule 2 to this bill and Schedule 5 to the UK Act both make provision extending to Scotland in respect of transgender people. These amendments are aimed at ensuring the provisions fit together. Amendment 57 makes various changes to amendments made to the Gender Recognition Act 2004. The first change is that the bill no longer replaces Section 4, 2 and 3 of the 2004 Act. This is already provided for by paragraph 3 of Schedule 5 to the 2013 Act, and so there is no need for this bill to provide for this as well. The second change is to add a new Section 41A to the 2004 Act. This provides that an applicant to the Gender Recognition Panel is to receive a full Gender Recognition Certificate, or GRC, if the applicant is neither married nor in a civil partnership. The third change is consequential on this second change. The fourth change amends for Scotland the new Section 4.3 of the 2004 Act as substituted by the 2013 Act. New Section 4.3 currently lays down that an interim GRC will be provided if the applicant is in a marriage that is not a marriage registered in England or Wales or overseas, or if the applicant is in a civil partnership that is not registered in England and Wales. The changes ensure that a person in a marriage solemnised in Scotland who has spousal consent to stay in the marriage, and a person in a Scottish protected civil partnership whose partner is transitioning on the same day can receive a full GRC. Amendments 62 and 63 make similar changes. Amendment 62 ensures that a person in a marriage solemnised in England and Wales or overseas who has spousal consent to stay in the marriage can receive a full GRC. And Amendment 63 ensures that a person in a civil partnership registered in England and Wales whose partner is transitioning on the same day can receive a full GRC. Amendments 58, 61, 64 and 65 just change the numbers of sections being added to the Gender Recognition Act 2004 to ensure there is no duplication with section numbers being added by the 2013 Act. And finally, Amendments 59 and 60 are consequential on Amendment 57, and Amendments 66, 69, 71 and 73 are consequential on Amendment 58. I therefore move Amendment 57.
Thank you, Cabinet Secretary. Do any members wish to speak? No. The question is that Amendment 57 be agreed to. Are we all agreed?
Agreed.
Agreed. I now call Amendments 58 to 67, all in the name of the Cabinet Secretary and all previously debated. Cabinet Secretary, I invite you to move Amendments 58 to 67 en bloc.
Move en bloc, Convener.
Do any members object to a single question be put in Amendments 58 to 67? No. The question is that Amendment 58 to 67 are all agreed. Are we all agreed? Agreed. We now move on to issue a full gender recognition certificate by a sheriff where spouse has not declared consent to marriage continuing. I now call Amendment 68 in the name of Linda Fabiani, grouped with Amendments 70 and 72. I ask Linda Fabiani to move Amendment 68 and speak to all amendments in the group, please.
Thank you very much, Convener. These amendments implement one of the committee's recommendations in the Stage 1 report. It recommended that the requirement for spousal consent for gender recognition is unnecessary and should be removed. It also noted that the non-transitioning spouse's personal choice is sufficiently protected by the automatic grounds for divorce triggered by his or her partners seeking gender recognition. Amendment 68 would enable a trans person who married in Scotland to obtain legal gender recognition without needing to first get written consent from their spouse. It also ensures that the spouse will have the right at any time to seek a non-contestable divorce on grounds of the trans person's gender recognition. The right to legal gender recognition is an established human right which should not be able to be blocked by another person. The rights of both the trans person and their spouse must be balanced in this bill. And as the bill currently stands, I don't believe that the right balance has been struck. Removing the requirement for written spousal consent for gender recognition will correct the balance and ensure that trans people have the personal autonomy to which they are entitled. There are, after all, many circumstances where a married person may act in a way that has an effect on their spouse, but where there is no legal requirement to obtain the spouse's written consent first. There is a trans person's decision to start living as the other gender and later to undergo gender reassignment surgery. Both have a huge impact on their spouse, but there is no legal requirement of spousal consent for them to make either of these steps. In contrast, the later issue of a gender recognition certificate is the final administrative step of recognising the transition that has already happened. It's a very important step for the trans person's practical rights because it means their legal gender comes into line with their lived gender. But the practical effect on their spouse is minimal. That is, minimal compared to the earlier steps of transition. It is therefore disproportionate to require the spouse's written consent to be obtained. As transgender equality is developing around the world, an increasing number of European countries are treating legal gender recognition as an entirely personal administrative process. Of the 9 European countries out with the UK that have same-sex marriage, not one has a spousal consent requirement for gender recognition. None of these countries has been subject to a human rights challenge because they don't have a spousal consent requirement, and I believe that that illustrates the ECHR compliance of my amendments. It is more likely, in fact, that the bill could be challenged for infringing the rights of the trans spouse if the spousal consent requirement remains in the bill. I believe it would be disappointing if we missed this opportunity to develop our laws in line with best practice. Amendment 68 inserts a new Section 4E into the Gender Recognition Act 2004. Section 4E provides that a trans person in a Scottish marriage who does not have written spousal consent for their gender recognition and who therefore obtains only an interim gender recognition certificate from the UK Gender Recognition Panel may then apply to the Sheriff Court to convert the certificate to a full certificate, bringing their gender recognition into effect. The application must be made within 6 months of the issue of the interim certificate. The route of an application to the Sheriff Court is used because the Gender Recognition Panel operates on a UK-wide basis, and it would be difficult for the panel to operate different rules for Scotland. My amendment is a Scottish solution to the problem, removing the need for spousal consent for Scotland only. Amendment 68 does not require the Sheriff to hold any hearing. In fact, that would be a very bad thing because it could turn the process into an expensive, slow and adversarial one. The role of the Sheriff here is purely administrative in converting the interim to a full certificate. The Sheriff is well placed to do that because converting an interim certificate to full is exactly what they do at present in cases where a person with an interim certificate obtains a divorce. Amendment 68 also requires that the Sheriff notifies the trans person's spouse that the application for the full certificate has been made and that it has been granted. This allows the spouse to apply for a non-contestable divorce if they wish to end the marriage. And the amendment specifies that their right to do that continues indefinitely, so they can take as long as they like to decide. Amendment 70 provides that where gender recognition has been granted in this way, a revised marriage certificate showing the marriage as a same-sex marriage can only be issued with the spouse's agreement. That gives the spouse the space to decide whether to seek to end the marriage without updated documentation related to the marriage being in circulation first. Amendment 72 ensures that the continuity of the marriage is not affected by the issue of the full gender recognition certificate. This means that the spouse's financial, parental and other rights associated with the marriage are not affected in any way by the gender recognition. I believe that these amendments correct an imbalance in the bill and will help ensure that the bill delivers equality for transgender people as well as for others. And I would ask the committee to support them, and I move Amendment 68.
Thank you. Do any other members wish to speak?
Yes.
I invite Marco Biagio.
Thank you, Convener. I would like to speak in support of this group of amendments, which, as Linda Fabiani has already pointed out, implement a recommendation that the committee came to unanimously in our Stage 1 scrutiny. I think the decision to transition gender is an intensely personal one, and I've heard testimony not only from people who have transitioned, but also, in one case, from the spouse of a trans person. And I would not want to see that intensely personal decision become one where another person has a right, essentially, to veto it. Marriage can lead to all kinds of changes. You know, when you marry someone, all kinds of unforeseen circumstances can come up. The singling out of this one particular change of circumstance, substantial though it is, I think is an unhelpful message when there are so many other things that could change as well. The protections are very strong. The divorce is uncontestable and is uncontestable forever. The 2 years during which a trans person would have to live in the other gender before seeking a certificate, which ensures that the partner is aware of what's happening and is not surprised by this, with the additional protection that the amendments have sought to introduce of the notification, and also the inability to get the new marriage certificate updated with the new details. As Linda Fabiani said, nowhere in Europe is this seen to be necessary, is the system that's in the bill seen to be necessary. And I think if I was to get married, I would not want in any way to feel that I was owned by my spouse, or that my spouse had any kind of veto over my personal life in any way. There are, I think here in the procedures, we're talking about two separate strands. There is the legal process of the marriage that you have to the other person, and then there is the very separate, very personal, very individual question of your gender. And we have to keep those two legal processes separate, and that's why I will be backing the amendments.
Thank you. I now ask John Finney to speak, followed by Alex Johnson.
Thank you, Convener. I share the views of the two previous speakers, and indeed will be supporting Linda Fabiani's proposal, which I think was delivered in a very measured way and shows that there are the protections there, the automatic right of divorce, and when it comes to any suggestion of the original marriage certificate being redrawn. Is this a human right for someone to reassign their gender? And I think the timetable of likely events as laid out by Linda Fabiani shows that all sides have been considered there, that the proposal is proportionate, but the word I would use that people would understand, I just think it's not fair as it stands at the moment, and this will introduce a measure of fairness, and I hope people will support it.
Thank you. Alex Johnson, please.
Thank you, Convener. I agree in principle with the amendments as they've come forward, and I wish to support that principle. However, I want to seek some reassurances in a key area. The concern I have is that the removal of spousal consent for gender transition is a circumstance which may, in certain cases, lead to concern. We know that there are such things as long-term estrangements within marriages. And we are, of course, talking here in relation to the Marriage Act. So the assumption would be that when gender transition is taking place, that a divorce would also be taking place in these circumstances. My concern is that the nature of the amendments do not create a situation where gender transition taking place without a parallel arrangement relating to marriage could result in a gender transition taking place without the consent or the knowledge of an estranged spouse.
Thank you, Mr Johnson. Can I now ask the Cabinet Secretary if he would like to comment, please?
Thank you very much indeed, Convener. And can I say also, I think Linda introduced this in a very measured and comprehensive way, but I have to be honest and say the amendments don't reflect the preferred approach by the Government. The bill removes the requirement for transgender people to divorce before obtaining a full gender recognition certificate, a GRC. In future, where both spouses wish to remain married, the Gender Recognition Panel will be able to issue a full GRC. The Government doesn't consider this to be a spousal veto as such. Instead, the bill ensures that both parties wish to stay in the marriage when it changes from being an opposite-sex marriage to a same-sex marriage or vice versa. We are balancing rights, and we've tried to do that, as you know, throughout the bill. We agree these are not straightforward issues. We accept that most other European countries with gender recognition legislation and same-sex marriage do not have the same provisions on the spouse consenting to stay in the marriage, other than England, obviously. Also, in most cases, the 2 years the applicant has to live in the acquired gender before applying to the Gender Recognition Panel protects the non-transgender spouse from a sudden change in circumstances. Generally, the non-transgender spouse has time to decide what to do. However, as we outlined in some detail in the response to the Committee's Stage 1 report, that may not be true in all cases. As a result, Amendments 68 and 72 do not reflect our preferred approach. There are some drafting points in areas such as divorce And in a substantive point under Amendment 68, the Sheriff is given no discretion at all. The Sheriff has to issue the full GRC as the amendment stands. And as a result of Amendment 72, the continuity of the marriage will be unaffected by the Sheriff issuing the full GRC. Therefore, the marriage will change from opposite sex to same sex or vice versa, even where the non-transitioning spouse has not consented to this change. Turning to Amendment 70, this relates to the proposed regulations on registering marriages following gender recognition. The amendment provides that both spouses would need to consent to this registration. I appreciate the rationale behind Amendment 70. This is aligned with what we intend the regulations will provide in any event. It could be argued, therefore, that Amendment 70 is not really necessary, as the regulations will be along these lines anyway. In conclusion, Amendments 68 and 72 don't reflect our prepared approach, and if they're carried, we will need to make some further amendments at stage 3 to ensure the proposed new procedures work effectively. Can I just say, if it is passed, I'm not suggesting we would try to reverse the stage 2 amendment. We would just simply make any consequential amendments we think are required to make sure, if the committee so decides, to make sure that the new provision works properly.
Thank you. I now ask Linda Fabiani to wind up and comment and press or withdraw, please.
Yeah, the comments are interesting. In response to Alec Johnson, I would say there is a non-contestable right of divorce. So I don't think that the spouse is being disadvantaged in any way there if they have been apart for a long time of their marriage. I think the amendment strikes a balance very well between the rights of the two spouses. I think it's a balance that the committee identified, and I think when you look at the evidence from other European countries, it makes the case for itself. I've listened to what the Cabinet Secretary has said. Take it on board, and I'm glad that there was the clarification that there is no desire to reverse these amendments. And of course, I'd be happy for the Scottish Government to... yes, of course. Sorry, Cabinet Secretary, if they pass. But I'd be happy, of course, if they pass, for the Scottish Government to tidy up the wording of these amendments at stage 3. And yes, Convener, I'd move Amendment 68.
Thank you. The question is Amendment 68 be agreed to. Are we all agreed?
Yes.
Yes. I now call Amendment 69 in the name of the Cabinet Secretary, already debated with Amendment 57. Cabinet Secretary to move formally, please.
Move formally, Convener.
The question is that Amendment 69 be agreed to. Are we all agreed?
Yes.
Yes. The question is that Amendment 69 be agreed to. Are we all agreed? Yes. I now call Amendment 28 in the name of the Cabinet Secretary, already debated with Amendment 4 on day 1. Cabinet Secretary to move formally.
Move formally, Convener.
The question is that Amendment 28 be agreed to. Are we all agreed? Yes. We're all agreed. We now move on to appeals against the issue of gender recognition certificate. I call Amendment 29 in the name of the Cabinet Secretary in a group on its own. Cabinet Secretary to move and speak to the amendment, please.
A very short introduction, Convener. The bill makes provision so that where an applicant to the Gender Recognition Panel secures a gender recognition certificate by fraud, their spouse may apply to the Court of Session to have the certificate quashed. However, as the bill currently stands, this right is not available to an applicant's civil partner. Amendment 29 corrects this and extends the right to civil partners to apply to the Court of Session also. I therefore move Amendment 29.
Thank you. Do any other members wish to comment? No. The question is then that Amendment 29 be agreed to. Are we all agreed? Agreed. I now call Amendment 30 in the name of the Cabinet Secretary, already debated with Amendment 25 on day 1. Cabinet Secretary to move formally.
Move formally, Convener.
The question is that Amendment 30 be agreed to. Are we all agreed? Agreed. Now moving on to registration of qualifying Scottish marriages and civil partnerships and the power to charge fees. I call Amendment 31 in the name of the Cabinet Secretary and a group on its own. Cabinet Secretary to move and speak to amendment, please.
Thank you, Convener. Amendment 31 relates to the regulation-making power on the registration of marriages and civil partnerships following the issue of a full gender recognition certificate. Amendment 31 makes it clear that fees could be charged to applicants in respect of registration. Fees are generally charged for registration purposes. I recognise, though, the sensitivities of charging fees in this area. The Registrar-General staff and the Scottish Government will discuss the issues here with stakeholders representing transgender people before making any regulation in respect of fees. Indeed, my officials have already had some preliminary discussions with stakeholders representing transgender people on procedures generally in this area. We will continue those discussions if and when the bill is passed. And I move Amendment 31.
Thank you. Do any members wish to speak? No. The question is that Amendment 31 be agreed to. Are we all agreed? Agreed. I now call Amendment 32 in the name of the Cabinet Secretary, already debated with Amendment 4 on day one. Cabinet Secretary to move formally.
Move formally, Convener.
The question is that Amendment 32 be agreed to. Are we all agreed? Agreed. I now call Amendment 70 in the name of Linda Fabiani, already debated with Amendment 68. Linda Fabiani to move or not move?
Formally moved, Convener.
Thank you. The question is that Amendment 70 be agreed to. Are we all agreed?
Agreed.
Agreed. I now call Amendment 71 in the name of the Cabinet Secretary, already debated with Amendment 57. Cabinet Secretary to move formally, please.
Move formally, Convener.
The question is that Amendment 71 be agreed to. Are we all agreed? Agreed. I now call Amendment 72 in the name of Linda Fabiani, already debated with Amendment 68. Linda Fabiani to move or not move, please.
Moved, Convener.
The question is that Amendment 72 be agreed to. Are we all agreed? Agreed. I now call Amendments 73 to 75, 33, 76 and 34, all in the name of the Cabinet Secretary and all previously debated. I now invite the Cabinet Secretary to move Amendments 73 to 75, 33, 76 and 34 en bloc.
Move en bloc, Convener.
Thank you. Do any members object to a single question being put in Amendments 73 to 75, 33, 76 and 34? No. The question is that all Amendments 73 to 75, 33, 76 and 34 are agreed to. Are we all agreed? Agreed. The question is that Schedule 2 be agreed to. Are we all agreed? Agreed. Agreed. I now call Amendment 35 in the name of the Cabinet Secretary, already debated with Amendments 15 on day one. Cabinet Secretary to move formally, please.
Move formally, Convener.
The question is that Amendment 35 be agreed to. Are we all agreed?
Agreed.
Agreed. The question is that Section 28 be agreed to. Are we all agreed?
Agreed.
Agreed. We now move on to grounds of divorce, the interim gender recognition certificate followed by full gender recognition status. I call Amendment 77 in the name of the Cabinet Secretary and a group on its own. Cabinet Secretary to move and speak to amendments, please.
Thank you, Convener. Amendment 77 amends the Divorce Scotland Act 1976. Under the 1976 Act, there are two grounds for divorce in Scotland. One is the irretrievable breakdown of the marriage, which can be demonstrated through a number of routes. The other is the issue of an interim gender recognition certificate, or GRC. The purpose of Amendment 77 is to amend the 1976 Act so that a divorce cannot be obtained on the grounds of the issue of an interim GRC, where the Gender Recognition Panel has gone on to issue a full GRC. This can arise under the new Section 4C of the 2004 Act, as inserted by paragraph 5 of Schedule 2 to the Bill. The scenario here is that the panel issues an interim GRC. Within 6 months, both parties consent to the marriage continuing, and an application is then made to the GRP for a full GRC. Given that both spouses have consented to the marriage continuing following gender recognition, it would not be appropriate for the issue of the interim GRC to be used in such cases to obtain a divorce. Amendment 77 amends the 1977 Act accordingly. If a spouse subsequently wishes to end the marriage, divorce on the grounds of irretrievable breakdown would continue to be available. And I move Amendment 77.
Thank you, Cabinet Secretary. Do any members wish to comment? The question is that Amendment 77 be agreed to. Are we all agreed? Agreed. The question is that Section 29 be agreed to. Are we all agreed?
Agreed.
I now call Amendment 36 in the name of the Cabinet Secretary, already debated with Amendment 4 on day one. Cabinet Secretary to move formally, please.
Move formally, Convener.
The question is that Amendment 36 be agreed to. Are we all agreed?
Agreed.
The question is that Section 30 be agreed to. Are we all agreed?
Agreed.
I now call Amendment 37 in the name of the Cabinet Secretary, already debated with Amendment 4 on day one. Cabinet Secretary to move formally.
Move formally, Convener.
The question is that Amendment 37 be agreed to. Are we all agreed? Agreed. The question is that Section 31 be agreed to. Are we all agreed?
Agreed.
Agreed. We now move on to no commencement of same-sex marriage provisions until certain amendments to Equality Act 2010 is in place. And I call the Amendment 49 in the name of John Mason and a group on its own. John Mason to move and speak to amendment, please.
Thank you, Convener. And the purpose of this amendment is obviously in relation to the UK Equality Act, which is a major player in this whole debate that we're having. And it's to ensure that the commencement of the same-sex marriage elements of this bill would be conditional upon the UK Equality Act 2010 being amended, specifying that the protected characteristic of religion or belief includes the belief in marriage as presently defined, and making clear that the compliance with the public sector equality duty requires ensuring that no one should suffer any detriment as a result of holding or expressing the view that marriage is between a man and a woman. Now, this is necessary because many of the concerns about this bill do not, in fact, originally stem from this bill, but it is a question of how it interacts with the Equality Act 2010, which is, of course, Westminster legislation. And we, I think, have previously discussed at this committee at other stages of the bill the fact that while the Equality Act lists a number of protected characteristics, it neither says that they are all of equal value, nor does it rank them in any particular order. And that has left the courts open to interpret that list of protected characteristics in the way they see fit. And it's certainly the feeling of some people that that has meant a hierarchy with religion and belief somewhere near the bottom. Now, government ministers have indicated that the concerns of those who do not favour same-sex marriage should be properly addressed. That's both the Cabinet Secretary and his predecessor. And in order to address these concerns, it's not only in this bill that requires amending, but the Equality Act itself. Now, I know the Scottish Government has been working with the UK Government to prepare amendments to the Equality Act, but I think this is related mainly to religious bodies and celebrants who do not wish to take part in the actual solemnisation of same-sex marriages. However, concerns with the Equality Act do go beyond that, and it's not just the issue of celebrants and what happens inside religious buildings. The wider issue relates to ordinary people, and especially perhaps to those working in the public sector. The Equality Act is meant to protect such people against discrimination on the grounds of religion or belief. However, the feeling, as I said already, is that if cases go to court, religion and belief are treated as less important, and so protection for such people is less. So that's why I would argue that the Equality Act needs to be amended to specify that the protected characteristic of religion and belief includes the belief in marriage as presently defined, thereby making clear that beliefs about marriage are covered by the religion or belief ground of discrimination law. Similarly, the public sector equality duty contained in Section 149 of the Equality Act puts public authorities under a duty to have regard to the need to discriminate, the need to eliminate discrimination. And that, within a quote, that eliminate discrimination is a quote, also quote, advance equality of opportunity and quote, foster good relations, all of which on the surface we would certainly welcome, including the need to tackle prejudice. So in theory, the Equality Act, including the public sector equality duty, It protects religion or belief just as it protects sexual orientation. But in practice, it means the local authority can choose which rights are more important in the event of a clash. I believe, therefore, we need a further amendment to the Equality Act, making clear that compliance with the public sector equality duty requires ensuring that no one should suffer any detriment as a result of holding or expressing the view that marriage is between a man and a woman. Ultimately, nobody in the public sector in Scotland should have their equality and diversity credentials and presumably their suitability for employment disputed merely because they hold to the existing view of marriage, and that's why these amendments are needed. The Cabinet Secretary has stated in his answer to written question S4W 17756, dated 12th November 2013, that, quote, public sector appointments should be based on merit and not on any views which applicants and staff may have on same-sex marriage, and therefore this is an opportunity to put that beyond doubt by accepting that these changes should be made to the Equality Act.
Thank you, Mr Mason. Alex Johnson would like to speak. Would any other members like to speak as well? And John Finney. Alex Johnson, please.
Following on from what John Mason has said, right through the Stage 1 inquiry, I and others express concern that while we fully accept that those who promote and support this legislation do so on the grounds of furthering equality and tolerance, there is a concern that in doing so the rights of others are being infringed. So in terms of how we apply equalities legislation, while we talk about this bill on its own, it must be taken in a broader context. And for that reason, I believe this amendment gives us the opportunity to consider this legislation in that broader context and ensure that as we progress towards the objective of the promoters of the bill, that we don't do it at the expense of the liberty and freedoms of others. And that's why I'll be supporting this amendment.
Thank you, Mr Johnson. John Finney, please.
Thank you, Convener. I think John Mason said a number of commendable things. I think we should always have ordinary people at the forefront of our deliberations rather than have it some sort of parliamentary academic exercise within here. I think it's commendable that John feels there's a need to tackle prejudice. The sensitive matters we've discussed have been areas of great prejudice over the years. John seems very concerned about a hierarchy of equality characteristics. I don't know if he wants a uniform. I don't know if he wishes to intrude into judicial decisions. It seems to me he wants preferential treatment. He wants a blank cheque with respect to people whose views many would find unacceptable. And for that reason, I won't be supporting his amendment.
Thank you. Do any other members wish to comment? I now ask the Cabinet Secretary, please.
Thank you, Convener. Can I say I do not support Amendment 49. First of all, this amendment relates to amending the Equality Act 2010, which is reserved. Therefore, any such amendment may give rise to competence issues. In any event, I do not consider that the suggested amendment to the protected characteristic of religion and belief in the 2010 Act is necessary. There's nothing in the introduction of same-sex marriage in Scotland which would mean that this protected characteristic does not cover the belief that marriage is between one man and one woman. And an amendment of the type proposed would raise questions and could cast doubt about which other beliefs are covered under this protected characteristic. In addition, Section 14 of the bill makes it clear that existing rights to freedom of thought, conscience, religion and expression are unaffected by the introduction of same-sex marriage. Similarly, I do not agree with the proposed amendment to Section 149 of the 2010 Act on the public sector equality duty. This duty is a duty to have due regard to the need to eliminate discrimination, advance equality of opportunity and foster good relations, rather than a duty to achieve a particular result. The effect of the amendment is unclear. It could potentially be very wide-ranging and is capable of being interpreted in many ways. It is unclear what public authorities would need to do to comply with subsection 9A. As a result, it casts doubts on how a public authority would perform its duty under the PSED. The suggested amendment seems to go beyond the duty to have due regard and would require public authorities to ensure that there is respect for certain views and no detriment. Achieving this might quite simply not be possible. It would be a very onerous duty, and local authorities and other public authorities do not have the power to guarantee what is proposed. And an amendment in this area could cast doubt about whether other beliefs are covered under the public sector equality duty. We are aware of concerns from religious bodies that a local authority may use the duty to prevent a church against same-sex marriage using a local authority community centre. However, we consider that a local authority who uses the duty to refuse to let premises to a body on the basis of the religious beliefs of the body risks a successful claim of discrimination. Given I do not support these proposed changes to the 2010 Act, I also cannot support an amendment which would ensure that provisions on same-sex marriage in the bill must come into force the day after these suggested amendments to the 2010 Act have been or are being brought into force. Therefore, I do not support Amendment 49 and invite the committee to reject it.
Thank you, Cabinet Secretary. I now ask John Mason to wind up, press or withdraw, please.
Thank you again, Convener. Yes, the mention which I made in my speech, in which Mr Finney refers to about a hierarchy, is very much the key to all this, I would suggest. And the basic problem is the weakness in the Equality Act. And as I have to, I think, mention before, I was actually involved on the committee looking at that Act as well. And this subject was discussed at the time, was expected to be a problem, and since it has proven to be a problem, because the Equality Act is a very, very good act in many, many areas, but it did not deal with this question of either all protected characteristics being equal or having a hierarchy. And certainly some of us feel that the result has been that a hierarchy has been created by the courts, because the courts were given too much freedom by the Act. And so we now move into this same territory with this legislation, which in itself, because of the certain powers being reserved, we cannot fully encompass maybe the protections that the Cabinet Secretary would like to give, because we know of the weaknesses of the Equality Act. But one thing I'm certainly not doing is asking for a hierarchy with religion and belief at the top of it. I'm just asking that, given there is a hierarchy, religion and belief should not be at the bottom. So, I mean, I do accept it's an untidy way of doing things, but that's because this Parliament, I would argue, has limited powers. But the concern, I think, is that you could have a public authority, a council, which is just particularly zealous in pursuing one angle on its public sector equality duty, and that could be used against people of a religious persuasion. So, I mean, I don't for a minute question the good intention of the Cabinet Secretary and others who think that the bill is robust at the moment, but I'm afraid I and others are not convinced, and I would want to press my amendment.
Thank you. The question is that Amendment 49 be agreed to. Are we all agreed?
No.
The Amendment 49 is not agreed to, so we'll now move to a vote. Can all those in favour of the amendment raise their hands, please? Can all those not in favour raise their hands, please? The result is 3 votes in favour and 4 votes not in favour. The amendment is therefore disagreed to. The question is that section 32 be agreed to. Are we all agreed? Amendment section 32 is not agreed to, so we will now move to vote. Can all those in favour of the section raise their hands, please? Can all those not in favour raise their hands, please? Can anyone wishing to abstain from the vote raise their hands, please? The result is 4 votes in favour, 2 votes not in favour and 1 abstention. The amendment is therefore, the section is therefore agreed to. Okay. The question is that section 33 be agreed to. Are we all agreed? Yes. Agreed. The question is that the long title be agreed to. Are we all agreed?
Agreed.
Agreed. That ends stage 2 consideration of the bill. Thank you all very much. Thank you.
Committee. Thank you.
Yeah. We will now suspend the meeting to clear the room, and then we will be moving into private session.